defendant?
West for this, my lord.
I'm not hearing you.
IG Sri Lanka for the
IG. IG who?
defendant. IG Sri Lanka for the defendant, my lord.
You have to make yourself available.
My lord.
Otherwise, I will report you. You have to put on your camera. Yes, IG Sri Lanka for the defendant.
Yes, my lord.
Yes, this matter is for judgment. The judgment of the court is ready. It goes like this. By the general form of complaints dated the 19th day of August 2020 and filed on the same date, the claimant claims against the defendant as follows. A declaration that the document entitled Letter of Dismissal, Samuel Iwank, Auditor Code 0077, dated the 5th day of June 2017 and addressed to the claimant by the defendant is null and void and of no effect, or in the alternatives that the purported dismissal of the claimant by the defendant is wrongful. A declaration that the claimant is entitled to the monthly salary of 74,481 naira 61 kobo from June 2017 till July, judgment is delivered in this court. C, a declaration that the claimant is entitled to full mandatory pension contribution scheme remittance from the defendants from June 2017 till judgment is delivered in this case. E, an order of this honorable court mandating the defendant to pay to the claimant the sum of 20,731,415 naira 31 kobo, being the amount due or loan taken by the claimant on behalf and on the instructions of the defendant as at July 15, 2020. An order of this honorable court mandating the defendant to pay the claimant the accrued and compound interest on the loan delivered in this suit. F, an order of this honorable court mandating the defendant to pay the claimant his full monthly salary of 71,481 naira 61 kobo from June 2017 till the judgment is delivered in this suit. H, an order of this honorable court mandating the defendant to pay to the claimant all the defendants' unpaid pension contribution from June 2017 till judgment is delivered in this suit. I, an order of this honorable court mandating the defendant to pay to the claimant the sum of 23,500 naira being commitment for the processing fee of to Onward Multipurpose Cooperative Society Limited. J, an order of this honorable court mandating the defendant to pay to the claimant the sum of 1 million naira being general damages for and other benefit accruing to the claimant, such as dependent local annual incentive, LAIP, salary increment, Christmas bonus, on which the claimant is entitled under the terms of his employment. An order that the dependent pays to the claimant the sum of 20 million naira being exemplary damages for the cruel, malicious, oppressive, reprehensible, discriminatory, and unreasonable conduct of the dependent. And lastly, an 10% interest on the judgment sum from the date of judgment till the final liquidation of the judgment sum, and for such further orders as this honorable court may deem fit to make in the circumstances. Upon being served with the originating processes commencing this suit, the defendant filed his statement of defense on the 10th of August 2022 with leave of court. The claimant filed a reply on the 6th of July 2023 to the statement of defense. The claimant testified in proof of his case on the 13th day of July 2023, while when Emmanuel Oguche testified for the defendant as DW1. Both parties tendered some document in evidence. They were admitted and marked as exhibit accordingly. The case of the claimant, due to time constraint and also my state of health, I won't be able to read the whole judgment. That is to say, I will skip the introductory part of the judgment, like the case for the claimant, I will skip it. The case for the defendant, I will skip it. I will also skip the submissions of counsel for the defendant, where he submitted 2 issues and argued. I have captured the argument in the body of the judgment. The claimant counsel submission also was based on 3 issues formulated by him. The argument was also captured in the body of the judgment. So I will go straight to the decision of the court. I have carefully and painstakingly perused the processes filed by the parties, evidence laid at the trial, documents tendered and admitted in evidence, as well as the written and oral submissions of counsel in adumberation of the case of their parties. From the claimant's pleadings, the reliefs being sought. The case put up forward by the claimant is that of for determination borders on issue of dismissal of claimant from his employment by a person not his employer. He is also claiming salaries for the period of his purported dismissal to judgment of this court. There is also claim for loan, which was accrued interest, which he took on behalf of the defendant. He is also claiming for general damages and exemplary damages. There is also claim in respect of pension contribution. So I shall consider the case of the claimant based on the 5 categorization I have made of the claim of the claimant. On the first category of the claim, it borders on issue of dismissal of the claimant from the employment of the defendant, on the nullity or otherwise of claimant dismissal from service by an entity that is not involved in the employment of the claimant, that is Nelson Nigeria, instead of AC Nelson Nigeria Limited. And also the claim by the defendant that his dismissal was wrongful, malicious, because he was not afforded fair hearing. On the other hand, because he persistently requested for payment due to him from the defendant. The defendant, in his response to this set of claims of the claimant, submitted on behalf, the counsel for the defendant submitted on behalf of the defendant that the claimant was wrong on his assertion, in that the law is that an employer has the right to dismiss an employee even where such right is not stated in the contract of service. This was the position of the court in cases that the defendant has cited in support, such as Simon and Asabi versus Bank of the North. It is also the contention of the defendant that an employee can be dismissed for misconduct or any action which an employer has deemed to be misconduct or gross misconduct. The only obligation is to ensure that the employee is given opportunity to defend himself. And in the case at hand, the claimant was given opportunity to defend himself. He was accorded fair hearing. Counsel in support of this relied on the case of UBA versus Oranube. I have carefully considered the evidence and argument and counsel relating to the issue of dismissal of the claimant. It is clear to me that from Exhibit E that the claimant in this suit was employed by the defendant and in the contracts of employment exhibit E, CWE, sorry, the claimant is duty bound at all times to act diligently and honestly. Also, according to the defendant, by the employee handbook, claimant had a duty to also not to engage in any action that will bring the defendant to disrepute, which means that the claimant is to act with integrity in performance of his duties under the contract. But for the defendant, the claimant breached that duty by not conducting himself in the way and in the manner expected by the terms and conditions of his contract of service, as he violated the staff handbook and also the code of conduct for employee. It was based on this that the claimant was invited to appear before a disciplinary panel, which he has taken the opportunity, appeared and defended himself. However, the panel found him guilty and dismissed him as per Exhibit CWD. I have no doubt in my mind that in an employment not having statutory labor, the employer has an unfettered right to dispense with the services of his employee, provided he followed the process, he followed due process, where employer has dispensed with services of his employee in accordance with the terms and conditions of service. The employee will not have any cause for complaint against the employer. See the case of Julius Berger versus Weke. The law is tried where an employer no longer wants the employee in his services, and that even where the termination or dismissal of the employee occurs, the employee is only entitled to what would have been due to him if the termination was duly done. That is a requisite notice of termination or salary in lieu of notice as damages. And the law is right that the court cannot force a servant on an employer in a simple employment of master and servant relationship like the one at hand. See the case of Kwara State Polytechnic, Ilorin versus Shitu. See also Garuba versus KCI Limited and others. See also OAC Pensions Limited and others versus Olaika. See also Ajuzi versus First Bank of Nigeria PLC. See also Eze versus Supreme Bank. See also Olanian versus University of Lagos. In the case of Akbar Ekwe versus University Press PLC, it was held that the authorities are reflect that an employer has the power to hire and fire any of his staff workers at any time for any reason or for no reason at all, and does not owe him any explanation of apology, provided it keeps to the terms of the agreement governing their relationship of master and servant in termination or dismissal. See Garuba versus Kwara Investment Limited. See also Iwuchukwu versus Wizu. The general principle in master and servant relationship is that a master who no longer savor the services of his servant can call it a quit at any time and does not even owe the servant any explanation or reason to dispense with the servant services, provided he, the master, respect the agreed terms and conditions of the employment, which under the common law is satisfied. Once the requested notice or salary in lieu of notice is given to the party affected, he cannot complain against the said action of the employer. The simple truth is that even where the master is mischievous and or outrageous in the way he sacks the servant, there is nothing the law can do in the situation that services of the servant is no longer required by the master, as the court cannot impose or force a servant, however willing, on an unwilling master. See the case of Kado versus CBN. See also Ido Niboye Ovu versus NNPC. However, from the facts and evidence before the court, this case is unique. Is unique from the cases of the governed by from the cases that are not governed by statutory provision. That is case of master and servant relationship governed by the common law. This case appears to be different as the facts of the actual dismissal of the respondents or termination of his employment is shrouded in controversy and uncertainty, in that the claimant dismissal was said to have been done by a stranger to his contract of employment with the defendant, i.e. Nelson Nigeria, and not by his employer, AC Nelson Nigeria Limited. In the case at hand, I do not think the cases cited by counsel for the defendants are applicable to the case at hand. In those cases, the termination or dismissal was by the employer himself and not by a third party or a stranger to the agreement between the parties. In the case at hand, the claimant was employed by AC Nelson Nigeria Limited as evidenced by Exhibit CWE, while by the Exhibit CWC letter of suspension and invitation, and that of Exhibit CWD letter of dismissal were all issued by Nelson Nigeria. The law as it is has conferred disciplinary power on the employer to discipline his employee, and the law does not allow a stranger or a third party to interfere in the discipline of an employee. Therefore, for the termination or dismissal of employee to be valid in law, it must be shown to have been done properly in accordance with the terms and conditions of service by the said employer, and not by a third party. And in the case at hand, the disciplinary action that culminated into the dismissal of the claimant from his service was initiated by Nelson Nigeria. It is clear to every discerning eyes that Nelson Nigeria is not the same with AC Nelson Nigeria Limited. Even exhibit Exhibit H which was said to have been signed by the claimant to, to be bound by the code of conduct, and also the purported handbook Council. I'm sorry for the disruption. I will continue from where I stopped. In the case of hand, the disciplinary action that culminated into the dismissal of the claimant from service was initiated by Nelson Nigeria. It is clear to every discerning eye that Nielsen Nigeria is not the same with AC Nielsen Nigeria Limited. And the staff handbook also is not relevant to the determination of the claimant's dismissal, as it came into effect in 2018 and not before, that is a year after the purported dismissal of the claimant. Since the claimant has raised incompetency of his dismissal by Nelson Nigeria Limited as evidenced by Exhibit CWD, the defendant ought to have gone a little further to tender the certificate of incorporation to convince the court that Nelson Nigeria Limited that purportedly dismissed the claimant from the service of AC Nelson Nigeria Limited are one and the same thing. This issue cannot be settled by address of counsel. In view of all that I have said above on this issue, I came to the conclusion that the dismissal of the claimant from the services of the defendant was wrongly done, as it was not done by the proper person or the person with authority. The person that dismissed the claimant interfered wrongly with his contract of service. As a stranger to the said agreement, he cannot the Nelson Nigeria cannot therefore purport to terminate the employment of the claimant from the services of AC Nelson Nigeria Limited. Having found that there is no valid dismissal, this means that claimant's employment with the defendant had not been validly terminated. He is therefore still in the employment of the defendant. With these findings, the claimant is entitled to be paid his salaries from June 2017 to date of this judgment at the rate of 71,481 naira per month. On the claim for pension contribution, it is regulated by law. Employees, it is regulated by law. That is Pension Reforms Act. Employees pension is not paid directly to the employee. It is usually paid to the pension fund administrator, where the employee had his retirement pension savings account. The law has paid the percentage of the contribution of employees to 8% and that of the employer to be 10%. In view of my finding that the claimant is still in service and entitled to his salaries, he is therefore entitled also to all his pension contributions from June 2017 to the date of this judgment. The defendant is therefore hereby ordered to deduct the pension contribution of the claimant from his salaries and add it to the contribution of the employer, that is the defendant, and pay the same to the pension fund administrator of the claimant, where he had his retirement savings account, for the pension fund administrator to accredit the claimant's account with the said pension contribution. I now turn to the claimant's relief or refund of sums money spent in execution of assignment given to him or loan taken on behalf of the defendant for the execution of validation at Uyo in Akwa Ibom State. There is no dispute between the parties that the claimant was sent to Uyo to perform validation in respect of British America Tobacco. There is also no dispute that the claimant went with his team to Uyo to execute the said assignment. It is also not in dispute that the claimant was not giving any money for the assignment despite his request for the money to be made available to him. The claimant stated that one Festus directed him to source for money for the execution of the assignment. Consequently, he approached Onward Multipurpose Cooperative Society and obtained a loan of 200,000 naira from the cooperative with a compound interest of 10% per month. But the claimant has refused and failed to pay him the principal sums he borrowed and also the accrued compound interest. That's why he is claiming for this court to order the defendant to pay him the principal sums plus the accrued interest, compound interest. It is clear to me from the evidence before the court that the bone of contention between the claimant and the defendant as regard to the issue of 200,000 naira borrowed by the claimant from cooperative society is the interest accruable to the said borrowed amount. The claimant insisted that there is no agreement between the defendant and the claimant for him to borrow money on interest. Strictly from Exhibit F, the loan agreement is between the claimant and the Onward Multipurpose Cooperative Society Limited. The defendant is not a party to that agreement. In law, a party who is not a privy to a contract cannot be held to be liable for the breach of the said contract or even to benefit from that contract, even where the contract was made in his favor. Once he is not a privy to the contract, he has no business in that contract. In law, it is not every. This means that the the agreement, as evidenced by Exhibit F, is only between the claimant and the cooperative society, and the defendant has no business be in that agreement, and he is not a party and has not taken part in that agreement. In law, it is not every act of staff of a company like the defendant that can be taken as act of the defendant. See the case of Ransom Industries Limited versus Abia State Community for Health Service, Social Welfare, and others, where the Court of Appeal, in defining who an alter ego of a company is, Inameka Abu JC as he then was in the case of NNSC versus the Bama, has this to say: a company is an abstraction. It must therefore act through living person, but it is not the act of every person of the company that bind the company. Those whose act bind the company are their alter ego. Those persons who become of their position are the directing mind of and will of the company, the very ego and corporate personality of the company. See Lamande Current Company versus Oceanic Petroleum. See also Fairline Pharmaceutical Industries Limited and another versus Trust Adjusters Nigeria Limited. The above clearly shows that it is the act of organs of the defendant that combine the defendant. In the absence of any agreement to show that the defendant had agreed on the interest on interest of 10% compound interest on the loan taken by the claimant from cooperative society, the defendant is not liable to pay that amount. The claimant, the agreement for the loan is between the claimant and the defendant is not a party to that. And there is nothing before the court to show that the defendant has agreed to payment of interest on the said loan borrowed by the claimant. So he used the money to execute the defendant's job, but there was no agreement for him to take a loan in which an interest could be charged. Having granted claim on salaries, and award of general exempt having shown that there is no any agreement between the claimant and the dependent on interest rate, I hereby refuse to grant any claim of the claimant based on accrued interest of 10% on the loan collected from onward multipurpose cooperative society. The claimant, the dependent has agreed to pay the 200,000 naira which the claimant spent on execution of the job at Uyo. However, the said sum is yet to be paid. As the evidence that is before the court, the claimant was only paid 171,000 naira as part of his terminal benefit from as balance after deducting what they term as wrongful deduction of salary, wrongful payment of June salary to the claimant. They did after deducting it, the balance of 172,000 was paid into the account of the claimant. Even that account was not meant for the settlement of the 200,000 naira which he had spent in the execution of the project, and which the claimant have agreed to pay the claimant the said amount, but have refused to pay to date. In view of my finding that the claimant is still in service, and in view of my finding, on view of granting of salaries from June to this date of judgment, the said amount which was paid into the account of the claimant will be part of the 200,000 naira the claimant paid into the account when the claimant spent in executing the assignment he was sent to execute in Uyo, and he is entitled to balance of the sum of 71,481 naira 66 kobo. The defendant is hereby ordered to pay the claimant these sums of money as balance of the 200,000 naira which is spent in executing the assignment in Uyo. Having granted the claim on salaries, on salaries, I am of the view that award of general damages and exemplary damages in this case will amount to double compensation. These reliefs therefore fail, and they are hereby refused. From all I have been saying above, on the whole, the claimant can succeed in part and only in terms of the following orders, which I make. They are: 1. The claimant dismissal is hereby declared wrongful for having been done by a party that has no power to do so. The employment of the claimant subsists from June 2017 to date. The claimant is entitled to his salaries as employee of the dependent from June 2017 to date of this judgment. The defendant is hereby ordered to pay claimant his salaries from June 2017 to date at the rate of 71,481 naira 61 kobo. The claimant is entitled to his full mandatory pension contribution from June 2017 to date of this judgment. The claimant is hereby ordered to deduct the claimant's contribution from his salaries and add to the dependent's contribution as stipulated by law and paid same to the claimant's pension fund administrator for the said amount to be credited to the claimant retirement savings account. The dependent is hereby ordered to pay cost of this act to the claimant in the sum of 500,000 naira. All judgment sums must be paid within 30 days from the date of this judgment, failing which 10% will apply 10% interest per annum will apply to the final liquidation of the judgment sum. Before ending this judgment, let me say here that even though there is no rule of law that compel a party to call a specific or a particular witness, it is always the law that for a witness to be credible and to give credible evidence before the court, that witness must be a witness that can competently give credible evidence in respect of the matter and issues. For the defendant in this case, it is entitled to call any witness of his own choice. Being an artificial person, it is only employees that can give evidence on its behalf. But even at that, for the evidence to be given against the defendant, it must make sure that the witness that is coming to give evidence on his behalf is a witness that is in the know-how of what transpired, or that is on the schedule on which the case is being tried by the court. It has been shown that DW1 knows nothing about the employment of the claimant, and he has nothing to offer before the court. His evidence is like having nothing before the court. I say no more on this. This judgment is hereby entered accordingly.
As the court pleases.
Please.
My Lord,
Yes.
we are very grateful. Yes, sir.
You are
My Lord, we are
welcome.
very grateful for your judgment. Thank you very much.
You are welcome. Yes, Registrar, call the next case.
Yes, my lord. Suit number NICN CA 28 2021 between Gerald Abang and 1 Nigerian Police Force, 2 Inspector General of Police, 3 Commissioner of Police in Imo State, 4.
Yes, appearance.
Wait, please, my lord. I am
Yes.
Benita, holding the brief of Dr.
Benita.
Sani. Benita.
Benita who? Sit down,
My lord.
Announce your appearance while sitting. Sit down. Announce your appearance while sitting. Benita who?
Benita Effiong. EFFIONG.
Effiong.
Effiong.
Yes.
Effiong. EFFIONG. Holding
For
the
the
brief
claimant.
of Dr. Yes, my lord.
Holding brief of who?
Dr. Sani Emmanuel.
Any other appearance?
My lord.
Since the judgment of the court by the general form of complaint filed on the 21st day of July 2021, accompanied by a statement of fact, witness statement on oath, list of witnesses, list of documents and photocopies of documents to be relied on. The claimant claims against the defendant as follows: a declaration that the claimant's employment as statutory labor same is regulated by statute, and the extent of regulation of the first defendant and the defendants are bound to follow same in all material respect, including disciplinary proceedings and the laid down procedure for termination or dismissal of his enlisted personnel from service. B, a declaration that the defendant failed, neglected, and or refused to follow the said laid down procedure and did not accord the claimant fair hearing once the defendant purported to dismiss the claimant from service of the first defendant. A declaration that the claimant was wrongfully dismissed from the first defendant service and purported dismissal is illegal, null, and void. a declaration that the claimant's employment in the service of the first defendant is still subsisting until formal separation in accordance with the due process of law, and order reinstating the claimant and restoring his full benefit and entitlement, including promotions to him and all internet all at all material times. F, an order mandating the defendant to compute and pay over to the claimant all areas of salary, emolument, perquisite, entitlement, and other benefit accruing to the claimant covering the period of wrongful dismissal from 27th August 2003 until judgment and compliance with the terms of the judgment in this case. In the alternative, an order directing the defendant to pay the sum of 225,201,428 naira 14 kobo. The defendant in this case, despite being served with the originating summons commencing this suit and hearing notices, all served through the postal services, fell and neglected to enter appearance and file defense to the claimant's action. This action was brought based on the claimant's processes as the defendant refused to honor all invitations by the court to appear to defend the case. Hearing in this suit commenced on the 8th day of March 2022, with the claimant testifying in proof of his case as CW1. After adopting his witness statement on oath as his evidence, CW1 identified the document he is relying on in proof of his case. The documents were admitted in evidence and marked as Exhibit 8 to 8. The case of the claimant, as can be gleaned from his statement of facts and witness statement on oath, is that he was born on 24th day of November 1969 and was enlisted into the Nigerian services of the first defendant on the 17th day of March 1996, where he was assigned post number 169930. The claimant attended and completed the requisite basic detective course at the first defendant basic detective school, Calabar, between 25th day of 1999. Counsel, I will skip considering the case of the claimant and the submission of counsel on that. I will go straight to the decision of the court.
As the court
Court
pleases.
of time constraint.
As the court pleases.
Yes, the decision of the court. I have considered the originating process commencing this suit with all the accompanying processes, the written and oral submission of counsel for the claimant. The facts of this case are simple and straightforward. The claimant was enlisted into the Nigerian police force in 1996. He attended different courses at the various institutions of the first defendant. The ordeal of the claimant started when the claimant, together with one ex-corporal, Ikpo or Biroha, were posted to the house of Honorable Justice Teresa Iheme Mosu, JCA, when the justice was a High Court judge of Imo State. Upon appointment of Honorable Justice Teresa Iheme Mosu to serve in the election tribunal at Federal Capital Territory, Abuja, the claimant and his colleague accompanied his lordship to Abuja. When ex-corporal Info Obioha took in while in Abuja, when the claimant notified his lordship about the illness, his lordship did not say anything. And when they solicited the intervention of one of the judges of the panel, his lordship became infuriated and asked the claimant and his colleague to return back to the base. On their return to their base, they were detained and tried in an ordinary room trial, and they were dismissed from the claimant was dismissed upon recommendation of review officer, which was contrary to the verdict of the ordinary room trial. Coming to the determination of the claim before the court, it has been established by long line of decided cases that burden of proof in civil cases lies on the person who asserts. Therefore, the burden is on the claimant in this case to establish his case by sufficient, cogent, credible, and admissible evidence to establish his case. This is because the burden in civil cases, no matter, is not static and may shift from one party to another depending on the facts and evidence or the pleadings of the parties. In the case at hand, the defendant failed to file statement of defense despite service on them of the originating processes commencing the suit and subsequent hearing notices served on them. The defendants also ignored all the invitations for them to enter appearance and file defense to the claim of the claimant. The conduct of the defendants in refusing to honor the court processes served on them clearly shows that they are not interested in defending the case or that they do not have any defense to the claimant's action. The scenario that played out with the non-filing of the defense is that the case is not being contested. In other words, all that the claimants about and evidence made by him at the trial are uncontroverted and unchallenged. The implication in law is that the defendants on record are deemed to have accepted all the abundance of the claimant in the statement of fact as true and correct. Therefore, facts not challenged, not controverted, are deemed admitted. See also Okaibo versus Police Service, reported in 2003, Nigeria Ukulele Report, Part 834, page 444. In the circumstances of this case, this court is only to grapple with the case of the claimant, as there is no defense filed in this to dispute what the claimant has averred, and no legal representation at the trial to have cross-examined the claimant. In Okaibo versus Police Council, Toby JSC of blessed memory has this to say: in this matter, the only case before the learned trial judge was the case of the appellant. In law, he can stand or falls by his case. The respondent did not defend the action. In most cases where the plaintiff's case is not challenged, he succeeds. This is because the trial judge has no other case to deal with other than the case stated by the plaintiff in his statement of claim and in oral evidence. His lordship continued at page 43 by saying that the basic principle of law is that where a defendant fails to file defense, he will be deemed to have admitted the claim or reliefs in the statement of claim. But where a paragraph of the statement of claim is notoriously false, the common knowledge of the court, like 10th day of July is Nigeria's independence anniversary, such a paragraph is not admissible because it is obvious is an untruth. Facts not challenged, nor controverted or admitted are also deemed to be admitted by the party. See Okaibo by Police Council, Sufra. And in the case of Egesimba versus Onuzuruke, the Supreme Court has this to say: where the only pleaded file in the statement of claim, absence of statement of defense means that no issue is joined by Ayola JSC as he then was. Therefore, the defendant's failure to file defense to the claim of the claimant in this case, they are deemed to have admitted the claim of the claimant before the court, and also that they have refused to join any issue with the claimant. The action of the defendant is tantamount to an admission. It is tried law that facts admitted need no proof. See the case of Akahal and Sons versus NDIC. See also Overseas Agency Nigeria Limited versus Brown Energy Trading Company. See Party Mehi versus Lawani. See also LSWC versus Sakamori Construction Nigeria Limited. See also FRN versus Abacha. See also Omale versus Federal Ministry of Land, Housing and Urban Development. The defendants failed or neglected to file statement of defense and has by their conduct or failure to file defense admitted the abandonment in the statement of claim, which are left unchallenged and uncontroverted or uncontroverted. See Highway versus Modiowa Nigeria Limited. See also United Nigeria Insurance Company versus Universal Commercial Industrial Company Limited. See also Akibu versus Oduton. In such circumstances, the law does not require proof of impliedly admitted facts, and where proof is even required, only a minimal evidence would be necessary to ground the claim. See Balogun versus UBA. See also Ebunike versus ACB. The court in such circumstances has no choice or option but under an obligation to accept same as correct position of the law, as the correct position of what is present. See the case of American Cyanide Company versus Vitality Pharmaceutical. See also Yusuf versus Lori. It is the law where claimant files his claim raising an allegation of fact against the defendant or one of them. Such defendant who does not admit the truth of the allegation must file a defense to contradict, controvert, challenge, or deny the allegation. In the case at hand, the defendants failed and neglected to file defense by operation of law. They are deemed by operation of law, they are deemed to have admitted the assertions of the claimant, and the court may preemptorily enter judgment against the defendant. See Ajibade versus Mayowa. See Moshud versus Bayero. In the case at hand, since some of the reliefs being sought are declaratory in nature, the claimant will succeed on minimal proof. See Azanebo versus Bayero University, Kano. A cursory look at pleadings and the pleading and evidence of the claimant will show that the claimant was tried in an ordinary trial as required by regulation, and at the end of trial, he was only informed verbally that he had been dismissed from service, and his salary was immediately stopped. It is also in evidence that the recommendation of the ordinary trial is that he should be demoted from the rank of corporal to constable, but the review officer altered the punishment of demotion to that of dismissal. It is also in evidence that the claimant has severally appealed for reconsideration of this case, but to no avail, even with the admission even with the admission as contained in XBF that Audley Room trial was fought was proud with irregularity, as he was not accorded fair hearing. He was denied opportunity to call witnesses to testify in his defense or to question his accuser. The claimant being a policeman whose appointment enjoys statutory flavor, he is entitled to be treated in accordance with the law. In accordance with the rules and regulations governing his employment. The only way to terminate such appointment with statutory labor is to adhere strictly to the procedure laid down in the statute. See Olorontoba Oju versus Abdurrahim. See also Bamboe versus University of Ilorin. See also Pakuade versus Obafemi Awolowo University Teaching Hospital Management Board. See also Oni versus Governor of Ekiti State, where in the termination and of an employment with statutory labor, the employer flagrantly omitted to comply with the procedure for the termination in the way and manner prescribed by the relevant statute. The termination is null and void and of no effect. See Olo Figure versus Abraham. In the case at hand, the claimant has admitted being tried in an ordinary room trial, but his quarrel is that he was not given opportunity to call witnesses or cross-examine his accuser. He also faulted the punishment of dismissal on the ground that the recommendation of the ordinary room trial is reduction in rank, but the review officer changed it to recommendation of dismissal. The defendant's failure to appear and file defense has deprived this court of having the opportunity of having the defendant's side of the story. Therefore, this court is left with unchallenged evidence of the claimant. The review officer, who not having power under the law to recommend higher punishment, the recommendation the recommendation for the dismissal of the defendant from reduction of cost to that of dismissal is ultra biased the powers of the review officer. Therefore, it cannot stand. The said dismissal of the claimant having been made in violation of the rules and regulation governing the employment of the claimant, the said termination is hereby. The said termination is ultra biased the powers of the defendant. Therefore, the dismissal is wrongful. This is because the defendant have violated the provisions of Section 393 of the Nigerian Police Regulation, particularly as captured in second schedule to the said regulation on the Inspector General of Police, Deputy Inspector General of Police, Assistant Inspector General of Police, Deputy Inspector General of Police, Assistant Inspector General of Police, and Commissioner of Police that can award punishment of dismissal. In the instant case, the review officer at the material time was an Assistant Commissioner of Police who did not have the requisite power to award punishment by way of dismissal to the claimant. The claimant also stated that he is entitled to promotion to be fair with his colleague employees. However, it has to be borne in mind that promotion is not automatic unless where it is shown to be vindictive for promotion apart from the 3 years stated by the claimant on each rank. There is no evidence to show claimant has met all the requirements for promotion, but he was refused. The claimant having not proved entitlement to promotion, same is hereby refused. The failure of the claimant to prove entitlement to promotion means failure of that relief in that regard. From all I have been saying above, the claimant has proved that his dismissal was wrongful from the service of the defendant, and he is entitled to some reliefs. I hereby make the following orders. A declaration is hereby granted that the claimant was wrongfully dismissed from the first defendant service and purported dismissal is illegal, null, and void. B, a declaration that the claimant's employment in the services of the first defendant is still subsisting until formal separation in accordance with the due process of law. An order is hereby granted reinstating the claimant and the restoring his full benefit and the entitlement. An order mandating the defendant to compute and pay over to the claimant all arrears of salary emolument, perquisite, entitlement, and other benefit accrued to the claimant covering the period of his wrongful dismissal from service. The cost awarded is assessed at 500,000 naira. Claimant is hereby awarded 500,000 naira. The defendant is hereby ordered to pay the said sum over to the claimant. Judgment is hereby entered accordingly.
As the court pleases.
Yes, Registrar, any other matter?
No, my lord, that's all for today.
Okay. Counsel, we thank you for being with us. We have come to the end of today's sitting. The administrator, you can end the sitting, please.